There's a photograph. It was taken on Horn Island. There's an attorney standing in it. And when that photo went up on screen during a live broadcast, a crisis communication strategist looked at it for a few seconds and said something that stopped the conversation cold. She said it was all optics, not some of it, not parts of it, all of it. And then she pointed to one specific detail in that image as her proof. And here's the thing. She didn't point at the island. She didn't point at who was standing there. She didn't point at the water or the boat or the timing. She pointed at something you almost certainly scrolled straight past. One detail. In a photograph you have already seen. And by the time this is over, a former judge and a crisis strategist, two people coming at this from completely different professions, are going to land on the exact same conclusion about why that trip to Horn Island happened at all. It has nothing to do with the investigation, nothing to do with evidence, nothing to do with finding out what happened to Nolan. It has to do with something else entirely. Something one of them says people in this position get very, very nervous about. Stay with me, because the detail in the photo is the small reveal. The reason behind it is the big one.
When moves like this happen, there's not a trained crisis person there, but there might be a lawyer or someone there who thinks they are. I second what the judge said, and I want to follow up on her line about amplify. When you amplify something, you are putting yourself into a conversation. And if you're talking about defamation, well, now you're a part of that conversation. So it makes it more difficult to claim it and actually prove it, when you do this. And this is a move where they're also complaining about the backlash. So you can't have a megaphone and amplify and then complain about the acoustics around you.
Here's the framework. Everything else hangs on. When a case like this reaches the media, you are no longer fighting in one arena. You are fighting in two. There's the legal process, the investigation, the evidence, the eventual charging decision, if there ever is one. And then there's the other court, the court of public opinion. It has no rules of evidence. It never adjourns. And it returns a verdict, whether you participate or not. Most people understand that intuitively. What they don't understand is how differently those two courts have to be handled. And that's the problem here, because according to the crisis strategist on that panel, the moment you make something public, the moment you create what she called a public availability, you have changed the narrative of the entire story, not adjusted it, changed it. You've opened the door and invited every single person watching to walk in and form their own conclusion. That's not a side effect. That is the mechanism. Now hold that thought against what actually happened. A group of young men, at the center of a nationally watched death investigation, went back to the island with representation, in front of cameras, with statements distributed to the press. And the strategists read on, that was not that it was sloppy. It was not that it was a mistake made in panic, or a group of scared kids stumbling into a bad decision. Her word was intentional. She said it was intentional, and that it would come with intentional conversation and dialogue as a consequence. Meaning, somebody chose this. Somebody sat down, considered the options, and decided that putting these young men back on that island, publicly, was the move. Which raises the obvious question, who? Before we get to who, let's talk about whether it even worked, because there was a former judge on that panel too, and her assessment was brutal in a very quiet, very professional way. She started by being fair about it. Going back to a scene, she said, is not unusual. It happens in criminal cases all the time. Legal teams do it. Investigators do it. You go back because you want to evaluate the location, understand the geography, see what a witness could or couldn't have seen. That part is normal, but here she used a specific phrase. She called it inherently premature. And the reason is simple. Nobody has been charged with anything. There is no case, there is no indictment, there is no trial to prepare for. You cannot be building a defense for a proceeding that does not exist. So when you conduct a scene visit in public before any charge at a moment when the entire country is already watching, you are not gathering information, you are producing content. And her assessment was that doing so at this stage raises more questions than answers and guarantees more scrutiny than you had before you started. Then she went after the interviews. Because that's the other half of this. It wasn't only the island. There have been sit-down interviews, conversations on channels, statements made on camera. And the judge said, flatly, that she would not have put anybody on anybody's channel at this point. Not one person, not one appearance. Her reasoning is the kind of thing that sounds obvious the second you hear it, and yet somebody clearly didn't hear it. Every statement made in public becomes a fixed record. Every one of them will be examined, transcribed, compared, and cross-referenced against every other statement that person has ever made about that night. And any inconsistency, any single one, weighs directly on that client's credibility. Not a lie, not a contradiction, an inconsistency, a slightly different order of events, a time that shifts by 20 minutes. A detail remembered one way in March and another way in April. That's all it takes. She said advising a client to do those interviews right now is doing them a disservice. Sit with that. That's an attorney saying the other side's legal strategy is actively harming the people it's supposed to protect. And then she gave the line that becomes the spine of this entire thing. She said, "This is not the time you amplify. This is the time you lower the temperature." And they're just not doing that. So the host asks the obvious question. He asks it half laughing, because the answer seems so clear to him that he can barely get through it. Does any crisis PR professional on this earth look at this situation and say, yes, go back to the island, do it publicly, put it out there? He couldn't see it. The strategist couldn't see it either. Both of them laughed at the idea outright. And then she gave her theory. She said, when you see moves like this, there is usually not a trained crisis person in the room, but there might be a lawyer or somebody who thinks they're one. That's the distinction that matters. Legal strategy and communication strategy are not the same discipline. A brilliant litigator can be a catastrophic communicator because the instincts pull in opposite directions. Law says protect the record. Communication says protect the perception. Confuse the two, and you get exactly what we're looking at. Which brings us back to the photograph. The host puts it on screen, and the strategist says the image explains it perfectly. Then she says this. This is not someone who doesn't want to be seen on that island, trying to quietly gather background information. This is the opposite of that. This is all optics, down to the color of the tank top. That's the detail. The color of the clothing in a photograph on a beach. Think about what that observation actually means because it is sharper than it first sounds. She is saying that somebody made a wardrobe decision, that in a photograph presented as legal fact-finding, a professional communicator can identify styling, framing, selection, the visual grammar of a planned image rather than a documented one. You don't choose the color of your shirt for a private site inspection. You choose it for a picture.
This is all optics. I mean, down to the color of the tank top even. So they want to learn more. They're putting this information out there. They're putting it out to the press. They're putting these statements there. And the quotes that are being used, they're almost like creating this barrier around the boys, in this area of town.
And she didn't stop at the image. She said the quotes being used, the statements, the language distributed to press Iamers are almost building a barrier around the boys. A wall, constructed in public, out of words, positioned between them and everybody watching. That is not evidence gathering. That is a campaign. If you've been following this case since the beginning and you want more of this kind of breakdown, take 1 second and hit subscribe. It genuinely costs you nothing, and it's the only reason this channel can keep going through every development instead of moving on when the news cycle does. Now here is where the contradiction becomes impossible to ignore. Let's be completely fair first. Getting a lawyer is reasonable. The host said so himself, plainly. If you are anywhere near the center of something like this, Retaining counsel is not suspicious. It's sensible. It is what any competent adult would advise you to do. Nobody on that panel argued otherwise. So the problem isn't the lawyer. The problem is the sequence. You lawyer up. You limit what you say through official channels. And then you go do interviews anyway. You go back to the island in front of cameras. You issue statements. You participate. And then you get angry at the press and the public for finding that contradictory. That's the part that doesn't hold, because you cannot claim the protection of silence while operating a broadcast. You cannot say we are not commenting and then comment extensively. And when the public notices the gap between those two positions, the frustration that follows is not a media conspiracy, it's arithmetic. The strategist took it further, into territory that has real legal consequence. There has been talk of defamation, threats of suits, letters, and her point was this: when you amplify, you insert yourself into the conversation. You become a participant in it. And if you are contemplating a defamation claim while simultaneously fueling the very discourse you say is damaging you, you have made that claim harder to bring and harder to prove. The judge backed the underlying law. The bar for defamation is very high, and the reason it's high is the defense. The defense to defamation is truth, which means anyone who files has to be prepared for what discovery opens up. Every question they've avoided in public becomes a question they answer under oath. And then the strategist delivered the line that should be printed and framed somewhere. You can't have a megaphone and amplify, and then complain about the acoustics. You are participating in the thing you're complaining about. So let's answer the question this whole thing has been building toward, because the strategist described a pattern. Not about this case specifically at first, about every case like it she's watched over years of doing this work. She said the first move is legal intimidation, cease and desist letters, defamation threats, motions filed, and publicized. And the target of that first move is not a defendant, it's the audience. Step 1 is painting the public as the problem. Step 2 is painting the press as the problem. She was explicit about the mechanism. When you put emotion behind a threat, it becomes, in her words, somewhat threatening. And that is the entire function. The goal is to force people into compliance by getting them to say nothing at all, not to win a case, to end a conversation. And then she gave her read on what that timing tells her. When legal intimidation is the very first move, or a very loud move, in her experience, it usually signals that the evidence supporting that threat might not be there. And immediately, in the same breath, she said this: "It does not mean anyone is guilty." She said it twice, in different words. Bad communication does not mean guilt, but bad communication comes with complications. That distinction matters enormously, and I want to be clear about it. She is not saying these young men did something. She is saying that as a professional pattern, aggressive early legal threats are more often a sign of a weak position than a strong one. That is a communications observation about strategy. It is not an accusation about conduct. So, what were they terrified of? Not the island, not the water, not the investigation, the backlash. She said it directly. People in these situations get nervous about backlash, and the reason they get nervous is a chain reaction. Backlash increases scrutiny, and scrutiny shines a light into areas you might not want lit. That's it. That's the fear. Not fear of evidence, fear of attention, fear of the second court, the one with no rules, no schedule, and no appeal. Fear of losing control of a story that had already gotten away from them before the first statement was ever drafted. Every move analyzed on that panel points the same direction. The island trip, the press availability, the interviews, the legal threats. None of it is defense preparation, because there is no charge to defend. It is reputation management. And there's one more layer to it that the panel found telling. The Friends retained an attorney who has represented Donald Trump. That attorney asked about the defamation angle, called it a distraction, and said the focus should be on getting to the truth of what happened to Nolan Wells. The strategist's analysis of that choice had nothing to do with politics and everything to do with audience. Her point was this: the moment you attach an ideology to a story like this, you are only speaking to half of the audience. You have written off the other half before you open your mouth. And that isn't getting to the truth. That's picking a side. She's watched that move play out for years, and her read is consistent. Whenever blame gets attached to a public narrative, whenever the story becomes the public is the problem, the press is the problem, she starts looking for the pattern underneath, whether it's a red herring, whether it's a distraction, whether it's a delay tactic to buy time until some of the facts land. The judge agreed the word distraction was fair but flipped where it points. She said the moves made since attorneys got involved are a distraction on some level, because they pull attention away from the evidence building that is so critical right now. And now the part that should make everybody uncomfortable, including anyone who has spent weeks pointing exclusively at one side. During the broadcast, a viewer asked a question in the live chat. A simple one. When was the last public update or press conference from investigators? Nobody on that panel could answer it. Not the host, who has covered this case for over a month. Not the judge. Not the strategist. 3 people who follow this professionally, and not one of them could name a date. Here is what is on the record. Early on, the sheriff indicated they did not believe there was foul play and were treating the death as an accident. That characterization was paraphrased on air, and it was described as the last substantive public statement of its kind. The district attorney posted on social media saying they would not rush to judgment and would not be rushed. And after that, brief exchanges. Someone catching an official walking to a car, walking into a building, short, unplanned, incidental, no press conference, on a case that has had national attention since day 2. The judge's position on that was unambiguous. 2 weeks in, you say something. You say we are investigating. We are exploring every lead and every tip. There is no stone left unturned. You say the ordinary things that every agency in the country says when a case draws this kind of attention. Instead, the first thing the public heard was a presumption of accidental. And then a month of nothing. That does not cool the temperature, that raises it. The strategist added a comparison that sharpens the point because she wasn't arguing that officials should simply talk more. She referenced another case where local authorities took the opposite approach, speaking at every available opportunity, appearing constantly. And in her view, it arguably made things worse. So her conclusion isn't more talking. It's this. Being public and being transparent are 2 different things. You can be cautious. You can decline to release findings you are legally prohibited from releasing. That's not the failure. The failure is the absence of transparency about the process itself. And here's what happens when that absence sits there long enough. It creates a vacuum. Vacuums get filled, always. They get filled with commentators, with lawyers doing photo opportunities on beaches, with ideology, with speculation that hardens into belief because nothing authoritative ever arrived to displace it. Every single thing this video has described, the optics, the tank top, the megaphone, the threats, the counter-threats, all of it grew inside a space that official silence created and never came back to fill. Let's be honest about what the public is asking for because it isn't much. The strategist laid it out in about 15 words. This is what we're investigating. These are the facts. This is what we know. This is what we don't know. This is what we're going to do next. That's it. That's the whole ask. Everything else, every move, every optic, every counter move creates conversations. And conversations complicate, they multiply. They pull further and further from the center of the thing until the center disappears entirely. And that center is not a photograph. It isn't a tank top or a defamation letter or which attorney represented which former president. It's a mother who lost her child, who has been waiting publicly while lawyers stage photographs and commentators argue and officials say nothing at all. She still doesn't have answers. That's what all this noise is burying. And it's the one thing every person involved in this, every attorney, every strategist, every agency, and yes, everyone watching, should be measuring their behavior against. If this is the kind of breakdown you want to keep seeing, subscribing takes 2 seconds, And it's the difference between this coverage continuing and it quietly disappearing. Everything you have heard here is commentary and analysis from legal and communications professionals speaking publicly. No one has been charged with any crime in connection with Nolan Wells' death. Nothing in this video alleges that his friends caused his death, and the experts quoted stated explicitly that the communication choices they criticized do not indicate guilt on anyone's part. These are opinions about strategy and messaging, nothing more. Tell me what you think in the comments. Was the island trip a legitimate legal exercise, or exactly what she called it?